for you to know whether an activity constitutes to child labor, you should look out for the mental and physical effects of the exercise or activity. You should also look at whether this activity is going to take away the child from the social things or from the normal activities that a child should engage in for them to grow and develop mentally and physically as required. Hello everyone, I'm glad to be here again today to answer very interesting questions from you. I'll begin with the first question, which is on child labor. You asked what constitutes child labor. So basically child labor is any act, work or economic activity that prejudices or puts the mental, physical, the social well-being of a child at risk. These acts do not necessarily have to be physical, because you can engage a child in a mental exercise that constitutes to work, which someone should be paid for. And in Kenya, we all know that according to the Children's Act, a child is anyone who's below the age of 18, and they're not allowed to do heavy work or work that will take them away from school or from the normal activities that a child should engage in for them to grow and develop mentally and physically as required. Another thing to note is that children between the age of 13 and 18 to 17 may sometimes be engaged in work, but for you to know whether or not a child should be undertaking some work, because sometimes even during holidays when children are at home, their parents expect them to help and do some duties at home or help out in some ways. So for you to know whether an activity constitutes to child labor, you should look out for the mental and physical effects of the exercise or activity. You should also look at whether this activity is going to take away the child from the social things. For example, if you give them work that will take the better part of their day, where they should also have some time to play with the other kids, maybe read or just do some things that will make them feel like a child, then that constitutes child labor. The next question is the procedure to follow for children who are in conflict with the law. So first of all, when a child or children commit offenses, they're not considered to be, we use different terms, legal terms, to address these children. We do not refer to them as criminals or accused, or we try to use lighter terms so that considering the age and maybe the developmental capacity of the child. So a child who's in conflict with the law is a child who's been accused of an offense, of acts which are against the law. First of all, if a child is in conflict with the law, when they're being arrested, incarceration should always come as a matter of last resort. Like if they're to be held in police custody, it means all other ways were not possible and they had to be arrested and held in police custody. And when they're being held in police custody, the police should ensure that they're held in separate facilities from the facilities holding adults. I know there's a provision in the Children's Act for remand homes for children, but you realize sometimes there are police stations which do not have these facilities or are not in communication with the remand homes for children. So what I saw some police stations do, they take these children to. There are also facilities for children who are in need of care and protection. These are children who are not necessarily in conflict with the law, but they need to be protected. Maybe they're running away from forced marriages, or they're running away from rape or abusive parents. Then they're taken to homes where they're protected. They're called homes for children in need of care and protection. So what other police officers do is that they take these children who are in conflict with the law and have the children stay there until the court resolves their matter and decide where they are to be held and such issues. But also that is also not a very good option, because you realize you making children who are actually in need of care and protection mingle with those who are in conflict with the law. But if you weigh the options, it's better than holding these children in facilities which are meant for adults. So then when it comes to trial, There are magistrate courts which are specifically meant to handle matters for children, and the magistrates are usually gazetted, and so they handle all children matters. So any child who's accused, they're usually taken to the magistrate court, and if they're found guilty, they're probably taken to correctional institutions, which are juvenile facilities for correction, which they can be released after some time. And in many jurisdictions, children who are convicted before the age of 18, the records are usually sealed. They're not open to the public because you understand the issue of age and basically giving children a second chance in life. Yeah, so I think that's about it. And then there are times when a child is accused alongside an adult. In some cases, they might end up being tried in adult courts in the High Court. For example, if they're accused of murder alongside an adult, then in such cases, then they might be tried in the High Court alongside the adults that they've been accused, they've been co-accused with. The next question is on presidential immunity. Someone asked, what is presidential immunity? And to what extent is the president protected while in office? And is it absolute? So basically, presidential immunity is the protection that a head of state is given during their tenure in office. They cannot be taken through civil or criminal proceedings while they're still in office. This is usually out to protect the president and ensure that they perform the functions of their office while they're still in office. Yeah, so it is not absolute because there's a limitation where if a head of state is accused of a civil or criminal offense and Kenya is party to a treaty which allows for them to be tried while still in office, then they can be tried. The immunity then does not apply. That is why you saw early in the beginning of our president, the current president Uhuru Kenyatta and his deputy, they actually went to Hague for their trial for the post-election violence claims. So if there's a treaty that allows for them to be tried while in office, then the immunity does not apply. Yeah, but generally they are protected from civil and criminal trials and proceedings during their tenure in office. But I also want to note that from the decision that was given by the Court of Appeal the other day, where the judge was saying that there's actually no office in Kenya right now that has been absolved of being liable or taking responsibility or giving account to the people of Kenya. So asking the president to give account of what they're doing in office and some things that need clarification does not have to constitute a trial or proceedings. So we should distinguish between proceedings and asking for accountability for public office. Yeah, so the final question from you guys is what is double jeopardy? So I just want to give a scenario. A man and a woman, let's say they're married. Then the man is killed, the wife is tried, and not the man is killed. It's assumed that the man is killed because he disappears. Then they say the wife has killed him, she's tried, she's convicted, she's given say 20 years. She serves the 20 years, comes out of prison, then realizes the husband was actually alive. He only moved to a different city or town, got married and started a new life altogether. Then the wife goes and kills the husband now, this time for real. So then the wife is taken to court again to be tried for killing the same man that she was tried and convicted for. So the question is, do you think she should be convicted again? Because she was tried and convicted that this man is dead, you've been tried. I'm not saying that is a real case scenario, because there's some things that they consider you have to produce a body and blah blah blah. But I'm saying that was an hypothetical scenario. So double jeopardy basically is a rule that protects you from being tried and convicted for a crime that you are tried previously and convicted or acquitted. Because when you're tried for an offense, you can either be convicted or acquitted. So if you're tried and acquitted the first time, or tried and convicted, and then the matter comes up again, you're protected from trial again for the same offense. So basically, it's a rule that protects you from being tried twice for the same crime or offense. So sometimes when the prosecutors draft these charges, they draft, you can be accused of 2 or more crimes that arise out of the same set of circumstances. So in that, double jeopardy may actually come into play there, because if you're accused of 2 crimes which took place at the same time under the same set of circumstances, and then let's say you've been tried for 2 offenses, so the court will have to look at whether the matters took place at the same time under the same set of circumstances, and if they did, does the prosecution intend to use the same evidence to convict you or acquit you of their offenses. So, and if the answer to both questions is yes, then you cannot be tried of the 2 offenses. You will only be charged with 1, because if you're tried with the 2 offenses or accused of the 2 crimes, then you will be, it's like serving twice for committing the same crime. Yeah, so basically it is a rule that protects you from being charged twice for a crime that was committed and you were tried and acquitted or convicted previously by a court of law. It has to be by a court of law. So kama mlienda mkasameana previously and then this time you're taken to court, it cannot be you cannot be protected by this law. Yeah, so basically that is it. Thank you for today's questions. I'm glad I've been able to answer your questions today, and I hope you'll keep sending in your questions for the next session of Ask a Lawyer. Thank you and have a good time. See you next time. Bye.